I am not throwing away my opportunity to make my voice heard this November.
Your vote matters.
Your vote matters.
It affects everything.
I hope you all understand that you have the power to shape our country's course.
Make yourself heard.
Tell the world that you care about what happens to it.
Our democracy in the country we love requires our attention, voice, and participation.
Because we matter.
Because you matter.
We will vote because we make a difference.
Felony disenfranchisement is the removal of the voting rights of those who are convicted of felonies. 48 states currently prohibit incarcerated felons from voting. It's ubiquitous, yet somehow most people never think much about it. Only Vermont and Maine never take voting rights from those convicted of felonies. 34 states prevent some released felons from voting for some period of time, and 20 states bar those with felony convictions from voting until they are no longer on probation. 10 states have even stricter laws. Arizona prohibits those convicted of multiple felonies from ever voting again, while Tennessee permanently disenfranchises those convicted of specific felonies, such as murder. In Florida, Kentucky, Virginia, and Iowa, all felons permanently lose their right to vote. These states have avenues for restoration of voting rights, but the process may be strict and arbitrary.
I deny restoration of civil rights. I deny restoration of civil rights. So at this point, I'm going to deny restoration of civil rights. I deny restoration of civil rights. I deny restoration of civil rights. So it's all denied. Well, first off, thanks for your work for the state.
Thank you.
At this point, I don't feel comfortable giving your restoration of civil rights, but congratulations on your work.
Altogether, felon disenfranchisement laws strip voting rights from more than 6.1 million Americans. While there have been many challenges to disenfranchisement laws, few have succeeded. In 1974, felons sued California, alleging that the state constitution's disenfranchisement on the basis of felon status violated the Equal Protection Clause of the 14th Amendment. Since the classification implicated the right to vote, the plaintiffs alleged that the restriction on the right to vote needed to be narrowly tailored to achieve a compelling governmental interest. However, the Supreme Court upheld the practice, since the 14th Amendment specifically recognizes the possibility that states may disenfranchise people for committing crimes. 11 years later, the court ruled Alabama's felon disenfranchisement policy unconstitutional under the Equal Protection Clause, holding that to invalidate a law on such grounds, a plaintiff must show both discriminatory impact and intent. However, courts rarely strike down laws as discriminatory because intent is incredibly hard to prove. The other main legal route to challenging felon disenfranchisement is the Voting Rights Act. Passed during the height of the civil rights movement, the law was designed to dismantle voter suppression tactics states used against African Americans and allowed for enforcement by both the federal government and by a private cause of action, a tort. Specifically, Section 2 prohibits states from instituting any practice that results in a denial of the right to vote on account of race. No showing of intent appears as a requirement in the statute. While the Supreme Court has yet to rule on the issue, some argue that the Voting Rights Act would require finding felon disenfranchisement invalid if the laws lead to a disparate impact on communities of color. However, circuit courts have been mostly unreceptive to this theory. The Second Circuit upheld New York's felon disenfranchisement law, and the 11th Circuit similarly upheld Florida's, on the grounds that Congress did not intend for the law to cover such practices, fearing holding otherwise would implicate constitutional questions of congressional delegated authority or upset the federal-state balance. The Ninth Circuit initially held that Washington's disenfranchisement violated Section 2, but later reversed en banc and ruled that discriminatory intent was necessary. So what are the implications of these laws? 1 in 40 Americans has lost the right to vote due to a felony conviction. As mass incarceration has grown, so has the size of the disenfranchised population. In fact, this disenfranchisement can have a disproportionate effect on communities of color. Black and brown bodies are convicted at higher rates than their white counterparts, and in turn, felony disenfranchisement has silenced the political voice of the already marginalized. Nationally, 1 in 13 African Americans is disenfranchised due to their felony convictions, a rate 4 times higher than that of non-black felons. At the state level, in Florida, Tennessee, and Virginia, about 1 in every 5 black people have lost the right to vote. In Kentucky, it's 1 out of every 4. These disenfranchisement laws have also led to the development of the never franchised, ex-offenders who were convicted of felonies before they were 18. As a consequence, today, an entire generation have never been and never will be eligible to vote. As more and more citizens lose the right to vote, our government loses democratic legitimacy. Disenfranchisement laws shrink the voting pool, remove those who are subject to U.S. law from the electoral process, and expect them to still reintegrate into society without the ability to have a say. This is a contraction of American democracy. So how do we view felons? And how do policymakers justify these laws? When we classify people as felons, we set them apart from others and make it easier to justify taking away their political voices. We speak of felons as actors whose prior criminal behavior is reflective of stable internal thoughts and preferences.
Which is, if we don't trust you to have a firearm, or to serve on a jury, or to serve in the military, or to serve as a teacher, why would we trust you enough to make a decision as profound as who the next president is going to be?
But this ignores situational factors like poverty, mental health, and educational access. Moreover, felon serves as a proxy for discriminatory attributions. Research shows that individuals have internalized associations between felons and their race and class. So using a felony conviction to disqualify someone from voting may just help us reconcile our knowledge that a racially biased system is wrong with the reality that we have established one anyway.
It's your case, which I'm sympathetic to. I want to see. I had lunch the other day with a felon who's a good friend of mine.
When we strip voting rights from felons, we assume that convictions are legitimate because of the process that produced them. But we all know that the criminal justice system disproportionately affects poor black males. This is process legitimation. Even just the existence of a process, no matter how flawed or unequal, legitimizes the outcomes. Yet we use these outcomes to assign lifelong consequences. Society tells us that we can fix injustice through the ballot box. But for many felons, the ballot box is out of reach.
Amendment 4 has been passed.
Justice depends on changing the narrative.